Good morning, everybody. This morning we still have a few speakers who were waiting yesterday and who, for lack of time, couldn't take the floor. We will start with them, but then we have a number of NGOs who would like to address us in relation to the issues we will be discussing today in the civil and political rights context. That is, and I will remind us, it's Articles 1 up to 11 that we will discuss today in the morning and in the afternoon, plus 27. So these are the two clusters. So I would like to really remind you then in your interventions to really focus on issues related to these articles. So I start from yesterday still. There's the Taiwan Association for Truth and Reconciliation, and then CPR's Watch and the Awakening Foundation, although I understood that the Awakening Foundation was speaking yesterday already, so I don't know whether there is anything in specific that you would like to add today. So the Taiwan Association for Truth and Reconciliation, please.
Well, thanks for allowing us to go first, and thank you for coming all the way here. Article 2 of the Covenant talked about when people's rights were violated, then the state should provide effective remedy. In Taiwan, the transitional justice remains very underexplored issues, let me allow to say that. We are a civic organization, and our name is Taiwan Association for Truth and Reconciliation. Unfortunately, we don't have a counterpart in the government. That means after, like, Taiwan started democratization for like 25 years. Up until today, we don't have a government-sponsored truth commission. And exactly because of that, so the current remedy the government has taken up to handle the transitional justice, the only thing they have done is financial compensation. It's as if the government understood the remedy only from the financial perspective. Besides that, the government has done very little to educate the society or to realize transitional justice. There are three major things. Let me do it quickly. The government hasn't really done yet, or has only done very little. The first thing is about truth finding. There is very little investigation and very little exploration of the past histories regarding the authoritarian times that Taiwan experienced for decades. And there is no property return. If your property got confiscated while you were unjustly imprisoned or sentenced, then even after you got released from the prison, there is no property return. And the third thing is probably the most serious thing is that there is absolutely zero perpetrators got punished, because the government has set up two foundations to handle financial compensations to the victims of authoritarian regimes. But up until today, we have had thousands of people who have applied and received the financial compensations from these two foundations. But then that somehow means that the government recognized that there have been at least thousands of people whose rights got violated during the authoritarian times. However, there is no perpetrator at all. And that's the most significant feature of the transitional justice issue of Taiwan today. So in our opinion, we think the government should put more government resources. The government should establish a truth commission or some sort of mechanism like that to handle the transitional justice issues in a more effective and a comprehensive way. Because the lack of the efforts from the government side, so up until today, the the histories during the authoritarian times in Taiwan is still understudied. And even for victims and their family members, they have a hard time to get access to the government files or archives related to themselves. So it's like, if I'm a victim of the authoritarian regime, I myself could have some, difficulty to access to the government archives or files on myself. So that kind of things happen to a lot of victims and their family members. So, and our organization has drafted the bill to demand more reasonable access to the government archives and the files. But unfortunately, the legislation efforts were blocked in our parliament, Congress, or what do we call legislative yuan. So that just shows the lack of initiatives and incentives or efforts on the government side. So I would just stop here.
Thank you very much, please.
Of course, access to documents about the past is crucial. I see there are many questions. Comprehensiveness, are you getting all the relevant files? Cost, you're being charged in order to obtain these documents. I take it even about yourself. Speed.
That recently has changed a little bit. Yeah.
You're getting an improvement there?
Yeah, the government reduced the fees.
And,
yeah, so it's like if you are applying to get access to your own files, then you can be waived for paying the fee.
And what about media getting access to past
Extremely
files?
difficult. Extremely difficult. The government make the claim that they have to obey the law of, we have
Privacy.
a law regarding personal information protection. Okay, so the bill we, as a civic organization, drafted actually is try to strike a balance between these two goals. On the one side, we think people should have reasonable access to all the government files and archives, especially if the archives and the files, is about themselves. But then on the other side, we also, try to, reasonably protect other people's information. But that bill, as I said, currently is not on the legislative agenda in Taiwan.
I should think that enjoys a high priority in terms of dealing with the past and as part
Exactly.
of
That's how we feel too. Yeah.
development of Taiwan's democracy
Exactly.
requires knowledge of what was done.
Yeah, exactly. I mean, that's exactly how we stand for on this issue because, transitional justice is a big chunk of transitional justice is about realizing what happened in the past and realizing in a very comprehensive way. Not just, in an abstract way, that the government might have done something wrong and that these people got compensated already. That, unfortunately, is the current understanding of transitional justice in Taiwan.
What is your position in terms of public hearings, naming names, calling people as witnesses? What's your experience on that?
We have absolutely no experience on that because, as I said, up until today, there is no perpetrator, so there will not be public hearing because there is no investigation. There is no further investigations either on the politics side or the history side. So, we feel that this has been an issue. As I said, when we say no perpetrators got punished, not only they are not criminally charged in any sense, but even under the current Taiwanese National Security Act, Article number 9, if you are a victim of the authoritarian times, not only you wouldn't get justice on the a judicial process criminal side, you wouldn't even you are not allowed to file a civil lawsuit against people who have done something wrong to you, even if you know very well who has done something wrong to you.
You're not allowed?
Thank you.
You are not allowed, according to the National Security Act, Article number 9. Yeah, because they have, that article basically is in our opinion, is an impunity article. Yeah, it created impunity.
Okay. Thank you very much. Now I call on CPR's watch in relation to list of issues number 5 and 6. Is CPR's watch here? If not, I still have the Awakening Foundation, list of issues number 1021. Was that covered by your intervention of yesterday? I think they're also not here. Okay, then we come to the NGOs that inscribed for the issues today, starting with Article 6, the Taiwan Alliance to End the Death Penalty. Please, you have the floor. Yes, yes, sorry.
The Taiwan Tongzi Hotline Association, we still have one recommendation about the Article 3 in ICCPR, but we didn't have the chance to speak yesterday.
But you were speaking yesterday.
That's for ICSCR. It's not for the ICCPR.
But
So-
it's for which organization now?
Taiwan Tongzi Hotline Association. So you can see on the list, 1, 2, 3, 4, 5.
Okay, is there anybody else? Because there's a somewhat confusion about we have so many different lists. I have now one list here, which I was told is the current list. But is there anybody else from yesterday who feels that he or she has not yet been allowed to speak? Then I would ask for your indulgence and give you the floor for a moment to speak on Article 3. Yes, please. You can do it from the back if you wish. Yes, okay. All right.
Hi, hello，早安，各位人早。
Good morning. On behalf of the Tongzi Hotline Alliance, I want to speak on behalf of some friends who cannot be here today. These people are some carriers, foreign carriers of diseases in Taiwan. I think in Taiwan's laws, gender equality, gender equity shall be protected. And our organization receives 30 calls in average each year about discrimination against sexual orientation, gender identity, and HIV issues in workplaces. But in these 15 years, the government has only received and handled 2 cases. We can see there is a huge gap between the 2 numbers. And enterprises in Taiwan do not have the power to ask their employees to have AIDS-related physical check, but many enterprises go on and do that. And when the employees complain about that, the government didn't do anything to help. Another issue for migrant workers is that when these migrant workers come to Taiwan, they have to be checked up for HIV virus. If HIV is found, then the Taiwanese government will quickly expel them. And well, this migrant worker is also from the LGBT community. Then the government says that if this foreign person can guarantee that he or she has the virus because the spouse has that virus. But it's very difficult because same-sex marriage is not allowed in Taiwan yet. So even though this foreign employee is infected with the virus because of the spouse, they cannot prove that he or she is having a marital relations. We know that there's a foreign friend who had been living in Taiwan for 40 years, but because he had HIV infection. He was expelled and he died in a foreign country. Another educator from Europe was expelled from Taiwan for the same reason, and now he didn't have a job in the European country that he is in. So we want the government to include anti-discrimination elements in the Employment Service Act. We also want the government to remove the HIV checkup requirements on migrant workers. These are what we think. Thank you very much.
Now we continue with the Taiwan Alliance to End the Death Penalty.
谢谢。各位委员您好，我是 FACE 联盟的执行长林心怡。那我已经将我们的
Good morning, I'm Lin Xinyi. You have my statements in English on your table right now. I want to talk about death penalty in Taiwan, and I'll be happy to answer questions, and so are my colleagues Li Yanghuan and Wang Guoyuan. In the Covenant's Watch reports on the two covenants and in the reply to the government's responses, our organization already explained a lot about the death penalty in Taiwan, and I want to summarize by saying that in 2009, Taiwan ratified the two covenants, but before that, Taiwan stopped executing people for 3 years. Ironically, after the ratification, the Taiwanese government went backward. The government started executing more people each year, and it started treating death row inmates worse. There are people on death row who may be innocent, but they don't have opportunity to retrial. There are two cases such as Qiu Heshun and Zheng Xinke. They have not been able to get their cases reopened like the Su Jianhe trio. And the government didn't only move backwards, it also violates the ICCPR over and over again. Since 2010, 15 people have been executed. They applied for amnesty, but they did not receive replies from the president's office about their applications. Some of them didn't have lawyers at their third trial. After their trials, there were no oral arguments about these sentences. The government also executed people who are mentally ill or mentally disabled. These are people on death row who were tortured, but the torture was never investigated. So in order to comply with ICCPR, we recommend that the government should take the following measures. First of all, to stop executions, increase dialogue with the public. And second, release a list of concrete steps and a timetable for ending the death penalty in Taiwan. Third, amend Taiwan's laws to comply with the ICCPR. The government says the law has not been amended yet, but that is not an excuse to violate human rights. And until these laws have been amended, the government must follow Article 4 of the Act on Implementing the Two Covenants. Article 4 says that the government shall comply with the UN Covenant. We believe Taiwan is to amend or make the following laws. First of all, non-deadly crimes should not be punishable by death. This needs to be changed immediately. Second, in death penalty cases, there should be oral arguments. Third, in death penalty cases, the defendant should have a lawyer at all of his trials and appeals. Fourth, Taiwan needs to amend the Amnesty Act. Fifth, in death penalty cases, the death sentence needs to be unanimous by the judges. Sixth, in their ruling, the judges should be required to say why it is necessary to give the death penalty and why life in prison would not be enough. And HRC and the ESR committee have said that the government shall not punish the mentally ill by death penalty. So when giving sentences, the judges should consider the mental situation of the defendant. And the government should stop organ donations from death row prisoners because this violates international and Taiwanese regulations on organ donations. My next point is that we should improve the treatment of death row inmates in prison, and information about death penalty should be transparent. This means the government should notify the families of death row inmates before they are executed. The government should publish a list of the people who will be executed and when they are executed. This concludes my statement. Thank you.
Thank you very much. Asma.
I have read all the submissions that you've made on death penalty. I have just a few questions, because as you know that there are restrictions and safeguards which obviously lead towards abolition of death penalty. But in that, do you have in Taiwan any offense which leads to mandatory death penalty? That is one question that I want to ask you. And that during this process, while people have been executed, have there been children, expectant mothers, cases where there was no lawyer or due process not given, like appeal, etc.? And you said that mentally challenged people had been, old people. So this is my question, basically. And are you reading up on the restrictions and safeguards that has been built by the UN Special Rapporteurs? Because that virtually actually takes away death penalty, and yet they have said that despite these restrictions and safeguards, the desirability is of abolition of death penalty.
I'll respond to your question. The second question, you listed a few situations. Among the death row inmates, as far as we know, 2 have been diagnosed as mentally ill, and they are death row prisoners. And there are another 2 that are mentally retarded. As for those who have been executed, 1 has been diagnosed to be of low IQ, who has been executed last year. As for the absence of attorneys, I think in our written report, we have made clear explanations. Right now, according to the Taiwan law, during the 3rd trial, these prisoners may not have assistance from an attorney. In reality, for the existing death row inmates, among them, dozens of them did not have a lawyer to defend for them in the 3rd trial, yet they have been sentenced to death. The court said, according to the Taiwan law, they did not need to have a lawyer during the 3rd trial. In fact, since 2006, no people have been sentenced to death. However, we have found among the 56 death row prisoners, there are elderly ones, yes.
You say that since 2006, no one has been sentenced to death?
我说的是没有绝对死刑
No mandatory death penalty. No, I'm sorry. The mandatory death penalty has been abolished since 2006.
Briefly, how many crimes gets you death penalty? Murder, but are there any crimes which do not have violence or lethal weapons used to it? So how many crimes actually do have death penalty in Taiwan?
42.
对啊，目前有可能被判处死刑的罪名的话有5个。
Five crimes, including murder, manslaughter, and drug-related crimes, but none of them is mandatory death sentence. But if you read the national report and our shadow report, you will find out that there are still many provisions, as many as 40 provisions are related to death penalty. We believe these provisions should be removed right away.
In relation to organ donations from death row prisoners, you say in your statement, this violates international and Taiwanese regulations on organ donations. So my first question is, because the reply of the government says this is all in accordance with Taiwanese law. And secondly, I am a bit puzzled by the statistics. In the official reply of the government, they say to date there was only one case of organ donation from a death row inmate before execution of the death sentence in Taiwan. That's paragraph 42. And that was because the older sister of the inmate had a dysfunctional kidney. But then later on, the report says, because we do not distinguish the identity of the donors, we have no statistics about the number of death row prisoners who have donated organs. Can you, I see there are certain contradictions. Can you help us? Do you know whether it is a usual practice that death row prisoners donate organs?
In terms of the related regulations, Taiwan has a Human Organ Transplantation Act, according to which all such transplantation surgeries have to take place in a hospital. And there's another law on the execution of death penalty, which says something different from the Taiwan Human Organ Transplantation Act. Basically, it says that the death determination has to be made right away in the execution site. However, the Transplantation Act says the death determination should be made in the hospital. That's why we say it's a violation of the existing Taiwan law and international law. Another point is organ donation before the execution. According to the national report, there is one such a case. I think it's a case about part of the kidney donated to the inmates' relatives. So this is something completed before the execution took place. I think your question in the LOI is whether the inmate has agreed to donate the organs after the execution. If that's the question is asking about, then there's no such statistics. As far as we know, among the 6 inmates that have been executed in last year, 3 of them donated their organs. As for other statistics, I believe the government may be able to provide you with more information.
Now we proceed to the Chinese Association for Human Rights, followed by the Judicial Reform Foundation. Please.
Mr. Chairperson, distinguished experts, good morning. I am an attorney at law. I'm also the president of the Chinese Association for Human Rights. I used to be a member of the Presidential Human Rights Advisory Committee during the former President Chen's administration. And I was also involved in the related laws, the laws related to the establishment of the National Human Rights Institution. However, it did not get passed in the legislative body. It's quite a pity. I have also served as a reviewer for the foundation in charge of making compensations for victims of the White Terror. We have reviewed over 10,000 cases and applications, and the country has paid more than 10 billion new Taiwan dollars. So indeed, a lot of efforts have been made in the area of transitional justice. However, according to a survey, according to the victims' families, they don't think it is enough to have apologies from the government or to receive financial compensation. They want to know who are the perpetrators. Without finding out who the perpetrator is, their sadness will not be soothed. I think this is something missing as we seek transitional justice. I think this point has been made by someone before me, and I agree with that fully. Since 1977, the Chinese Association for Human Rights has been established, dedicated to helping refugees, and we have been promoting the enactment of the Refugee Act. We are also concerned about judicial reform so as to avoid miscarriage of justice. We are also promoting the enactment of the Amnesty Act, which has not garnered enough attention, nor has it been completed and passed. We are also promoting the idea of human rights in taxation. In fact, our headquarters in Geneva just published a very important document and statement yesterday. So I would like to bring your attention to this new statement. Last but not least, in response to the page 89 of the national report in relation to the use of torture in some death row inmate investigations, especially the Su Jianhe case. Why do we need the Amnesty Act? I think this, of course, has to do with the Article 6, paragraph 4 of the CCPR. There must be due process of law. In other words, no execution of prisoners can take place without replies from the president on his decision of granting amnesty or not. As for the Su Jianhe case, though compensation has been made to Su Jianhe, yet that is not enough because the prisoner has been put behind bars for more than 20 years. I don't think financial compensation is enough. Government has to take action to make up for the mistake in incarcerating the prisoner for over 20 years. So the Amnesty Act has to be completed and revised as soon as possible. And I hope in your concluding observations, you can make statements related to these issues. That concludes my remark. Thank you.
Now we have 3 organizations wanting to speak on Article 7, the Judicial Reform Foundation, the Taiwan Association for Human Rights, and the Taiwan Action for Prison Reform. Please.
Good morning. I am Luo from the Judicial Reform Foundation. Our foundation is most concerned about the Articles 6, 7, 9, 10, and 14 of ICCPR. In particular, Article 14, which has to do with people's right to a fair trial. The Chu He-shun case was decided long time ago. Before the decision was made, Chu He-shun was detained for 23 years. And Chu He-shun, in the end, was sentenced to death. During this long process, our foundation has done a lot to help this case. And we are also concerned about the evaluation of the performances of prosecutors and judges. There should also be a punishment scheme or regime for these judicial personnel. However, despite the fact that there is the Judges Act in place, it doesn't have teeth. For example, there are restrictions on people's right to file complaints against judges and prosecutors. So instead, we received a lot of complaints from people. As for the evaluation of these prosecutors and judges, the existing laws do not have effective ways to evaluate their performances. So I think the Judges Act is not helpful to improve the quality of these personnel. Another issue has to do with the judicial independence. Very often, the judges and prosecutors would work in offices adjacent to each other. So we believe that when it comes to the training and selection of judges and prosecutors, separate tracks should be adopted. For example, there should be a separate and independent training center for judges, different from that for prosecutors. Moreover, the right of migrant workers and immigrants, their right to institute litigation has not been protected fully. In particular, the court interpreter system. Right now, the district prosecutor's office does provide interpreters. However, these interpreter services are not used widely. As a result, very often, non-professional interpreters may be recruited. Sometimes interpreters who have conflicting interest with the defendant may be recruited to help to provide interpretation services. In fact, most prosecutors and judges are not willing to recruit interpreters because they think it's a hassle. So we believe that government should review the existing court interpreter system. They should also understand the needs of these new immigrants and migrant workers. The same goes for the languages of the indigenous peoples who also need interpretation services in the court. Last issue has to do with the detention. We believe detention is a violation of people's liberty and security of person. During the investigation period, the court does not have sufficient data or information to judge whether the defendant should be detained. However, if the charge involves a very serious crime, usually the defendant will be put in detention. In Taiwan's detention center, there is no adequate environment to allow the defendant to communicate with his attorneys. Moreover, the environment in the detention center is very similar to that in the prison. So this is a great impediment or harm to the dignity of the defendant. And many criticisms have been voiced. So we believe the detention period has to be shortened. For example, no more than 20 days can be allowed for detention. Thank you for your attention.
Thank you very much. May I ask the Taiwan Association for Human Rights on Article 7?
各位委员好，代表台湾人权促进
Good morning. I'm Ong Guoyan from the Taiwan Association for Human Rights. I want to talk about the foreign workers who suffer torture. I would ask the permission to talk about torture imposed on foreign people and the procedures of the repatriation. These issues are related to number 27, number 39, number 49 in the list of issues. I believe you have my written statement that includes our responses to number 27, 39, and 49. I hope I can be allowed to speak on these three issues in one time. First of all, we don't see any non-refoulement cases. We have not seen foreign workers who are sent back from Taiwan to their countries where they may suffer torture, but we still think these regulations should be included in our laws. And in 2009, there was a draft of Refuge Act, but the draft was not passed. But the content of that draft did not include non-refoulement principle. Instead, there were many exclusion clauses to consider many people as not refugees. And I think the draft should be changed. So due to the fact that there are no special rules or regulations, the government usually deals with the refugees and asylum problems case by case. If the foreigner does not accept deportation order and tries to apply the principle of non-refoulement, neither clear reviewing standards can be used. And on the detention of foreigners, there are regulations in our laws saying that, setting the ceiling of the day of detention as 120 days, but the grand jury interpret that this duration is way too long and asks the government to change the law. The Grand Justice thinks the appropriate duration should be 15 days. And if it has to be extended beyond 15 days, then the courts have to make reasonable decisions. So we ask the Immigration Act to be revised. If the detention is going to go beyond 15 days, the court must make a formal decision. And the Immigration Act applies to foreigners only, not on Taiwanese citizens. In fact, there are many Chinese people from mainland China who come to Taiwan illegally. They overstay. And for them, it is possible that they are or can be detained for an infinite time. And we think this fact violates people from the PRC, and we demand the act to be changed. The CRC committee, not very long ago, asked government to release children from detention centers. However, based on our statistics, by 2011, there were 9 mothers who didn't want to separate themselves from the children. Therefore, the children were also kept in the detention center, and we think these violate CRC, and we think the government should change their practice. Thank you.
I'm afraid the last NGO to speak is the Taiwan Action for Prison Reform, Article 7.
Good morning. I am here on behalf of the Taiwan Action for Prison Reform. And what I want to report to the committee today is that the prisons in Taiwan are set for corrective purposes, but we are not being able to see whether the prisons serve that purpose. There are several serious problems in our prisons. For example, not enough medical care, and there isn't enough social supports, and there are other issues as well. But today I want to raise three problems and 2 recommendations, and I want to show you a drawing. You can see this is a prison officer's drawing. This officer who manages in Yilan County like to draw about where he or she works. You can see that there are 13 prisoners who are cramped into one same cell, and it is not unusual. It is very common. And last week there was a proposal from the Control Yuan that asked MOJ to change the situation in the prisons. And each inmate can enjoy a very limited space in the prisons. And the insufficiency of managers and prison officers is another problem. Ideally speaking, the ratio of prison officer and inmates is 1:16, but now one officer must take care of more than 100 prisoners. One prison officer must take care of more than 100 prisoners, which is apparently an overload for prison officers. And the recidivism in the past 10 years is as high as 47%, which shows that the educational and corrective purposes and objectives aimed by our policies have failed bluntly. And the policy to criminalize drug use cannot prevent people from using drugs. Instead, it leads to the overcrowding of the prisoners because many of the inmates are put behind the bars because they use illegal drugs. And another problem is the use of instrument of restraints. You can see in this drawing, this is a very sick inmate. He was emulated, but the prison still put restraints on this person, and there was no supervision on the use of restraint instruments. we have interviewed some inmates, and these inmates told us that he had been put on with shackles for more than 20 days. He wanted to file a complaint, but ironically, the procedure is that he had to send the complaint to the prison officer who put the shackles on him in order for his complaint to be submitted to a higher level. So for inmates, it was very difficult to seek external remedies. That's why we have two recommendations. First of all, we want the internal situation of the correctional facilities to be known by the public. So we need an external supervision mechanism. We need to invite external inspectors to come in to correctional facilities to inspect or to receive complaints from the inmates. We want there to be such a mechanism so that we want to establish a prison ombudsman mechanism so that the general public understand the situation in the prison, so that the public will call for the government to change relevant laws and regulations in order to improve the prison situation. Thank you.
Thank you very much. Unfortunately, it is 10 o'clock now, and at 10 o'clock the review meetings with the government is starting. So I do apologize that some NGOs that had registered for today unfortunately cannot speak now, but of course, as we said, the review meetings with the government are public, so you are very welcome to participate, to attend these discussions, and perhaps there might be a possibility also of informal discussions with members of our committee during the breaks or after the session. So with this, the NGO meeting this morning is adjourned. We have another one tomorrow morning, and I just request that you organize the speakers in a way that we manage in this 1 hour time, that those who would like to address us in relation to the topics we will be discussing tomorrow with the government, that can be accommodated. I know that 1 hour is not very long, but on the other hand, there's still quite much that we can discuss during that time. Thank you very much for coming, and I hope we see you anyway again during the day and also tomorrow. Thank you.